You hire someone, they cause harm. Are you on the hook? That is the question vicarious liability answers, and the answer is sometimes yes, even when you did nothing wrong yourself. Vicarious liability is a form of secondary liability in tort. It does not replace the tortfeasor's own liability. Both remain liable. To establish it, a claimant must satisfy two main elements: a qualifying relationship between the defendant and the tortfeasor, and a sufficient connection between that relationship and the tort committed. We will build each element in turn. The first question is whether the relationship between the defendant and the tortfeasor is one that the law recognizes as capable of giving rise to vicarious liability. The paradigm case is the employer-employee relationship. That is well settled. The more difficult question is whether a relationship that falls short of employment can still qualify. The Supreme Court addressed this directly in Barclays Bank Furrows Various Claimants, 2020, making clear that the fact a relationship is akin to employment is not sufficient on its own. What matters is whether the tortfeasor is carrying on business on their own account. On the facts, the bank was not vicariously liable for an independent medical examiner who ran his own practice. Independent contractors will ordinarily fall outside the scope of vicarious liability for exactly that reason. They carry on their own enterprise and bear their own risks. So the starting point is always, is this person genuinely integrated into the defendant's organization, or are they an independent operator? Once a qualifying relationship is established, the second question is whether the tort was committed in the course of that relationship, or, to use the modern formulation, whether there was a sufficiently close connection between the relationship and the wrongdoing. The close connection test was confirmed by the House of Lords in Listerville Hesley Hall in 2001. The defendant ran a boarding school and employed a warden who sexually abused children in his care. The House of Lords held the school vicariously liable because the warden's role, caring for and having authority over the boys, created the very opportunity and context for the abuse. The connection was close enough. A year later, in Dubai Aluminium v. Salam in 2002, the House of Lords applied a broad approach to the test in a commercial fraud context, confirming that the close connection principle extends beyond cases of physical abuse. The contrast is with what older cases called a frolic of the employee's own, where the employee has departed so significantly from anything connected to their duties that the link is broken entirely. Whether that threshold is crossed is always a question of fact and degree. Vicarious liability is secondary. It can only arise if the tortfeasor has themselves committed an actionable tort. The claimant must prove every element of the underlying cause of action against the tortfeasor. This might be negligence, trespass to the person, fraud, or another recognized tort. If the tortfeasor has a complete defense, or if an element of the tort is not made out, then vicarious liability cannot attach. This point is sometimes overlooked by students who focus only on the relationship and the connection, but it is logically prior. There must be a wrong to be vicariously liable for. Non-delegable duties are a related but distinct concept worth distinguishing. A non-delegable duty arises where the law imposes an obligation on a defendant that cannot be discharged simply by entrusting performance to another person, whether an employee or an independent contractor. The Supreme Court clarified the scope of this doctrine in Woodland Varvey Swimming Teachers Association in 2013, identifying categories including schools supervising pupils and hospitals providing medical treatment. On the facts, a local authority that had delegated swimming lessons to an independent contractor was still held liable when a pupil was injured because the duty to ensure her safety in that activity was non-delegable. The practical effect is similar to vicarious liability. The defendant pays, but the legal mechanism is different. Here, the defendant's own duty is engaged, not the tortfeasor's. Time to test yourself. A care home employs care workers. One worker deliberately assaults a resident during a night shift. Is the care home vicariously liable? Option A, no. Deliberate acts can never trigger vicarious liability. Option B, no. The assault was outside the course of employment. Option C, yes. Lister establishes a close connection between the role and the opportunity to assault. Option D. Yes. Employers are always liable for acts done on their premises. The answer is C. Lister v. Hesley Hall confirmed that a deliberate wrong can still satisfy the close connection test where the tortfeasor's role created the opportunity for that very harm. Options A and D are both incorrect statements of law, and B misapplies the Lister test. Vicarious liability requires three things: a qualifying relationship, employer and employee being the core case, an actionable tort committed by the tortfeasor, and a sufficiently close connection between the relationship and that tort, judged by the Lister close connection test. Non-delegable duties operate alongside this framework where the defendant's own obligation cannot be outsourced. Your modules, mapped to your uni, explainer videos for every topic, a tutor that knows your course, essay writer for your essays and graded, case briefs, flashcards, annotations. Try it free for 7 days, link in the description.